Saturday. I've got oil in my hair. Oil. So Saturday, 16th of July 2016. 1 o'clock p.m. exact. I didn't do any exercises today because today's Saturday and I want to keep Saturdays as my day off. So, I think I'll try and want to. Where the hell? Yes, that one. Okay. No, I don't want to exit. Oh, there is. So what do I do? I should probably. I will stop that. There you go. So let me see if I can increase this. That sounds. Oh, shit. So I'm just gonna read from this. So you are forewarned. You are forewarned. You are forewarned. This is going to be me reading from this. From let me see if it's the Uniform Conduct Practice and CPD Rules for Solicitors 2015. Can you actually see this? Yeah, it's clear enough, I think. So, this is to show that I am aware of my professional obligations. I mean, it is serious, but I just can't believe this. I don't have to make this video, but I feel like making it. Okay, it's forward. Dear colleague, this year has been a particularly significant year for the solicitors of New South Wales. So that's 2015, I think. It has seen the introduction of the Uniform Legal Profession legislation. I think that legislation, don't quote me on this, but this is to make sure all the states in Australia have the same kind of legal rules regulating the conduct of solicitors, I think. I don't know. But don't quote me on it. That's right, this is just my personal channel. It has also been the 800th anniversary of the signing of the Magna Carta. 800 years ago, right? These events both serve as reminders in their own ways of the importance of the rule of law to the proper functioning of our society. So what is the rule of law? The rule of law states that no one is above the law, even the king or queen. I think that's what the Magna Carta did, right? No one can be above the law, even the executive. As solicitors, we have a vital role in upholding the rule of law to execute, because the administration of justice, yes. To execute that role, we are bound by strict ethical obligations. Our paramount duty to the courts, our fiduciary duty to our clients. They mostly focus on the fiduciary thing, but I guess that's what they're mostly concerned about, I guess. But confidentiality and our professional duty to our colleagues form the core of our ethical obligations. So when your duty to your colleagues, one example is like you should treat them respectfully. You shouldn't be rude, and that's one of the duties, or one of the examples. I'm sure there are many others. One of the most important functions of the Law Society is to assist our profession in upholding its ethical obligations. We support the whole profession with guidance and education, and there are contact details at the end of this booklet. Yes, this booklet is a handy reference to the conduct, practice, and education rules. I think conduct may refer to individuals' conduct. Practice may refer to law practice, the organizations. Education rules refer to the CPD, continuing professional D? What the hell does the D stand for? Anyway, I hope it proves a useful collection for you in your daily practice. Yours faithfully, John Eads, President, 1 September 2015. Okay, so uniform conduct, practice, and CPD rules for solicitors 2015. So this is the contents. It's about 40 pages, I think. The conduct rules, 5 glossary of terms for the conduct rules, practice rules, CPD rules, and contact. This is more detailed. Legal profession uniform law, Australian solicitors, conduct rules 2015, contents. Oh my god, should I read this? Part 1, preliminary rules. So there's citation, commencement, objective, authorizing provisions. Oh, these are part of the rules, I think. Part 2, operational rules, nature and purpose of the rules, application and interpretation, purpose and effect of the rules, fundamental duties of solicitors, so paramount duty to the court and the administration of justice, other fundamental ethical duties, dishonest and disreputable conduct, undertakings. Okay, dishonest, lying. I still can't believe they picked out my YouTube video. Disreputable, so bringing profession into disrepute, yourself into disrepute. Relations with clients, communication of advice, client instructions, confidentiality, conflicts concerning former clients. I think I've mentioned something about that. Conflict of duties concerning concurrent clients, conflict concerning a solicitor's own interest, completion or termination of engagement, which is like a retainer. When you engage a client, it's a retainer, it's called. Client documents, lien over essential documents, charging for document storage. Lien, I'll have to Google it. It's like a charge, like a, anyway, I'll Google that. Advocacy and litigation, independence, avoidance of personal bias, formality before the court, frankness in court, so you gotta be honest upfront, delinquent or guilty clients. So if a client is guilty, can you act for them, and how can you act for them? So that's an interesting kind of thing. Responsible use. I mean, you can't. If a client is guilty, you can't tell that they are not guilty, but you have to try and make the opponent prove that they're guilty. But you can't argue that they are not guilty, because that would be lying. Responsible use of court process and privilege. So don't waste the court's time by engaging in litigation for other purposes. Communication with opponents, opposition, access to witnesses, integrity of evidence, influencing evidence, so you can't coach witnesses. Integrity of evidence, 2 witnesses together. I did read a paper on this witness thing for my CPE thing for PLC. Communication with witnesses under cross-examination, solicitor as material witness in client's case. There has to be a. You should, anyway, I'll read that, but it's usually not. I'm just commenting, so please don't take everything I say. This is to the LPAB watching. Public comment during current proceedings. So that's like making media statements. You shouldn't make statements in the media that may influence. There was a thing about that. Prosecutor's duties, relations with other persons, another solicitor's or other person's error, inadvertent disclosure, unfounded allegations, communication with another solicitor's client, dealing other persons, dealing with other persons, or dealing other persons, contracting with third parties. That may refer to people who are employed to do work to obtain particular evidence, like you hire a consultant to do particular services. Oh, so this is law practice management, advertising, supervision of legal services, returning judicial offices. Sure what that means, probably to do with judges. Sharing premises, sharing receipts, mortgage financing and managed investments, anti-discrimination and harassment, dealing with the regulatory authority. Okay, so now we got a page 6, right? So this is page 5, so this is page 6. This is the conduct rules, part 1, preliminary rules. So I guess this is what the actual rules are. One is citation. 1.1. These rules are designated as legal profession conduct rules and may be cited as the Legal Profession Uniform Law Australian Solicitors Conduct Rules 2015. So this was passed in 2015, so last year. Commencement. These rules come into operation on 1 July 2015. So that's the beginning of the financial year, right? Yes, because the financial year ends at the 30th of, or the last day of June, so 30th June. Objective. The objective of these rules is to assist solicitors to act ethically and in accordance with the principles of professional conduct established by the common law and these rules. So the common law is the law that's made by judges. It's in the cases. And the rules are legislation passed by parliament or some other authority, legislative body. So usually the rules and the common law are like the rules codify the common law, but the common law, it might contain some ways of interpreting the rules, like some guidance on how judges have interpreted particular rules, or it might contain nuances or something, but usually the rules codify the common law. Authorizing provisions. Anyway, that's just my comment. I'm not an authoritative body. I should just say that. I'm just a person. I'm just a human being. I'm just reading this. These rules were developed by the Law Council of Australia in accordance with Section 47 of the Legal Profession Uniform Law and are made by the Legal Services Council under Part 9.2 of that law. Okay, so I guess this section of this gives this body the power to develop this rule, right? There's always like when you think about law, is like you have to always one of the things you got to do is where's the source of that law, because we live in a country that is the rule of law is paramount. So if a public body has the power to do something, its power to do something should be authorized by either legislation, usually, or the common law, or equity, which is another source of law. So that's why they're saying these rules were developed by this body in accordance with this section. Should I actually Google that? Maybe I will Google it. Legal profession uniform law. Let me just go to the internet. Yeah, okay. Just want to see what that section says. I don't want to make these two videos too big, just keep them under 30 minutes, hopefully. Okay, legal profession, uniform law. I'm going to this site called Ostley. 427, right? 400 a... Okay. So it's in chapter 9, part 9.2, legal profession uniform rules, section 427. Oh my god, it's such a big section. So basically, development of legal practice rules, legal profession conduct rules, and continuing professional development rules. So CPD stands for continuing professional development. Okay, so section 427(2) says, the Law Council of Australia may develop proposed uniform rules to which this section applies, so far as they apply or relate to solicitors. Section 427(3) says, the Australian Bar Association may develop proposed uniform rules to which this section applies, so far as they apply or relate to barristers. The barristers have the Australian Bar Association. So the Law Council of Australia deals with solicitors, it seems to me. Yes. Okay. Alright, so how many minutes? Oh, 17 minutes. I can read a little bit more. So this legislation gives power to this body to make rules that regulate the behaviors of solicitors. Part 2, operational rules, nature and purpose of the rules. Nature and purpose of the rules. 1, application and interpretation. These rules apply as the legal profession conduct rules under the legal profession uniform law. So this is the parent legislation. To solicitors and Australian registered foreign lawyers acting in the manner of a solicitor. So these rules apply to solicitors, not to barristers, to solicitors. In Australia, you get like 2 types of lawyers. Solicitors or barristers. You can be one or the other, but you can't be both. If you want to be a barrister, you have to actually go to the Bar Association and do a bar exam. And you have to score 75% on it, something to pass it. So you have to do an extra. But you just register for the course, and they give you some books, and you learn what's in the books. And every I think it's there's a timetable of exams, and you do the exam. And then I think you have to work as a junior barrister with a senior barrister or something. Anyway, so that's an extra step you have to do. The definitions that apply in these rules are set out in the glossary. So if you want the definition, you go to the glossary. To purpose and effect of the rules. The purpose of these rules is to assist solicitors to act ethically in accordance with the principles of professional conduct established by the common law and these rules. Okay. That's the purpose. In considering whether a solicitor has engaged in unsatisfactory professional conduct or professional misconduct, the rules apply in addition to the common law. So, yeah. So, if you, as a solicitor, there are 2 ways when you can be penalized. One way is you can be found to have acted engage in unsatisfactory professional conduct, and the other one is professional misconduct. Now, out of these two, unsatisfactory professional conduct is the less severe of the finding. Like professional conduct, misconduct is more serious. See, it's like it's got a more positive kind of like it's more active. Like you did something like professional misconduct. Unsatisfactory professional conduct is where you haven't achieved the standard. Like you acted, you weren't that diligent, or you weren't that, you were incompetent in performing your duties. That kind of thing where you're not achieving the standard. With professional misconduct is when you actually do something actively wrong, like you lied to the court, or coached witnesses, or you did something actively wrong. That is much more serious. Whereas unsatisfactory means you weren't living up to the standards. So that's still a penalty. You can still be, I don't know, lose your practicing certificate, or some cases you may be struck off the roll, which means you can't work as a solicitor. Like there's a roll is like a listing of the solicitors who are officers of the Supreme Court. So if you're struck off the roll, see what I'm trying to seek is I'm trying to get my name in the roll. That's what this admission process is. This admission process is to get me onto the roll of solicitors of the Supreme Court of New South Wales. So I'm on that roll. Now, if I want to work as a solicitor, I have to get another certificate called a practicing certificate, which is issued by the Law Society of New South Wales, and you have to pay like $830 for that, and that I think it renews every year. You have to get that. So you can be on the roll, but you don't have to work. If you want to work, you have to have the practicing certificate, as is my understanding. Okay, a breach of these rules is capable of constituting unsatisfactory professional conduct or professional misconduct, and may give rise to disciplinary action by the relevant regulatory authority, but cannot be enforced by a third party. Oh, I guess like if you, that's like saying like a client cannot sue you on the basis of a finding by this regulatory authority or whatever. If they find you, let's say the Law Society or whatever body that investigates claim of unsatisfactory or professional misconduct, and if a finding is made against you, a third party such as your client or another affected party, they cannot sue you based on this finding. Only the authority can do a disciplinary action. But I'm sure the client can sue them in court separately. But like a civil claim or whatever. But this is a separate kind of finding. This is to regulate, punish, discipline solicitors. Cannot be enforced by a third party. Oh, that'd be interesting. I think what that really actually means in practice. 23 minutes, all right. All right, so I'll just read a little bit. Fundamental duties of solicitors. So these are some of those duties, which there might be apparent conflict between them, but you have to. But in actuality, there is no conflict. That's what the court will say. No, the court will say you have a duty to the court about the interests of your client, which is true. I mean, you can't lie to the court, but so paramount duty to the court and the administration of justice. So 3.1, the solicitor's duty to the court and the administration of justice is paramount and prevails to the extent of inconsistency with any other duty. So let's note that down. A solicitor's duty to the court and the administration of justice is paramount. It's the most important duty, and prevails to the extent of inconsistency with any other duty. So if your duty to the client means like you're trying to serve your client's interests and needs, and in doing so, let's say it comes into conflict with being honest to the court. Obviously, the honesty to the court has to prevail, and you cannot lie for your client. I get it. I take it seriously. I'm laughing now, but I take it seriously. Other fundamental ethical duties. 4.1. A solicitor must also, 4.1.1, act in the best interests of a client in any matter in which the solicitor represents the client. 4.1.2, be honest and courteous in all dealings in the course of legal practice. So see how they're using the word courteous? Maybe lawyers have a reputation for being very rude. So, try and be courteous. 4.1.3, deliver legal services competently, diligently, and as promptly as reasonably possible. So this is how, you have to be competent, diligent, and you have to be efficient. Don't take too much time. So that's a way you can be found guilty of unsatisfactory professional conduct if you're not competent or diligent. Let's say there was a date by which a certain statement of claim, like if the case has to be started by a particular date and you were delayed in starting the case, let's say when the date passed, that shows that you're not competent and diligent. That shows failure of being competent, and the client can't sue or whatever because you fail to act on time. 4.1.4, avoid any compromise to their integrity and professional independence. Integrity, be independent, don't let other people sway you, try and form your own judgment. And 4.1.5, comply with these rules and the laws. So comply with the legislation and the common law. Okay, number 5, dishonest and disreputable conduct. 5.1, a solicitor must not engage in conduct in the course of practice or otherwise, which demonstrates that the solicitor is not a fit and proper person to practice law, or which is likely to a material degree to 5.1.1 be prejudicial to or diminish the public confidence in the administration of justice, or 5.1.2 bring the profession into disrepute. Now, this is where I think this mostly deals with honesty, and especially honesty in the realm of fiduciary affairs. Like you have to, this, I would say overwhelmingly, this honesty stuff deals with if you're dealing with clients' accounts and stuff, you have access to confidential information about bank accounts and all of you have a lot of access to clients' information, and you have to protect that confidential information, and you can't use clients' money for your own purposes. I think I read cases where sometimes solicitors go and withdraw money from the trust account, which is an account that's kept to store client fees or not fees, but their money or whatever. They may just withdraw that money and then put the money back, but that's still unethical because you cannot use, unless the client has given permission for you to do it, you cannot just take the client's money held on trust and use it for your own purposes. So that's kind of an example of where you're the public might lose confidence in the justice if you are behaving badly. And for me personally, I make a lot of YouTube videos, and so I'm thinking like, like I don't know, maybe going forward, like, I mean, all my videos up there, but I'm trying to think to what extent are my personal views going to. I don't think they can. I have I have a right to have political opinions. I think in the Constitution of Australia, you have a right to hold political. I think the political opinions is a fundamental right. I'm not sure, but I have to check. Like you can't be discriminated on the basis of race, religion. Uh, I think also political opinions. So I can hold political opinions. So I don't think my YouTube videos would bring the profession into disrepute. But I am kind of conscious of it. But I don't think. But I will. It's something that I'm thinking about. Like, how am can my YouTube videos undermine the public confidence in the administration of justice? Because that just, what do I do? I'm very open or whatever, but anyway, so I think this mostly relates to financial things, money things. That is what they're worried about. Don't don't misuse clients' money. That is the main kind of thing. Anyway, I'll leave it at 5, and I will continue from 6 onwards. Like, the mouse keeps on going up and down. I will continue that tomorrow. And now we can bring this back. Oh no! I gotta take a shower. This is yeah. That's it. Okay. I'll put it back. Oh.